In 1913, a newspaper in New York City printed a story alleging fraud at the customs house on the waterfront. That goods were coming through the port with duties quietly forgiven, and that men inside the government knew about it. The government wanted to know who had talked. A federal grand jury was convened, and the city editor of the paper, a man named George Burdick, was called before it. He was asked to name his source. He refused, and he gave a reason. Answering might tend to incriminate him. He stood on the Fifth Amendment. Now, ordinarily, that is where a story like this ends. The witness refuses, the prosecutor fumes, and the grand jury moves on. What happened instead is one of the strangest things in the history of American law. The President of the United States, Woodrow Wilson, issued George Burdick a full and unconditional pardon. Burdick had not been charged with anything. He had not been convicted of anything. No one had accused him of a crime. The pardon named no offense because there was no offense to name. It simply declared him forgiven for any violation of the customs revenue laws he might have committed, and it was delivered to him for one purpose, and one purpose only. The reasoning was elegant, and it was this. The Fifth Amendment protects a man from being forced to give evidence that could be used to prosecute him. If the man cannot be prosecuted, he has nothing to fear from his own answers. And if he has nothing to fear, he has no privilege left to stand on. Pardon the witness, and you have taken away his silence. Burdick refused it. He was brought back before the grand jury, handed the document, and told he was now obliged to answer. He declined to accept the pardon. He declined to name his source. He was held in contempt, and he took his case to the Supreme Court of the United States. And in January of 1915, the court held that he was right. A pardon is not a command. It is a deed, and a deed requires delivery and acceptance. A man may refuse one, and the court observed something about why a man might want to. A pardon carries an imputation of guilt. Accepting it is a confession of it, and no citizen is required to accept a confession he does not owe in order to purchase a silence that was already his. A pardon nobody asked for, issued to a man nobody had charged, for the express purpose of taking away his right to remain silent. That was 1915. And it will be back before this episode is over. This is episode 9, part B. This is No Man is Bound to Accuse Himself. I am Jeff Kellick, and this is the Consequential Actions Podcast. This is episode 9, part B of the series, Self-Evident, The Road to 1776. Our contemporary application episode, connecting the historical principles we explored on Saturday to the questions in front of us right now. And before we go on, 2 pieces of plain speaking. The first is this. Tonight we are going to talk in detail about a Senate hearing held on the 29th of July and about a committee vote taken 5 days ago, and about Anthony Fauci. That means partisan conduct by named people in a live proceeding. I'm going to describe what a Republican senator did, and I'm going to say I think he is wrong about it. And I'm going to describe what Democratic members of the committee said, and note where their record does not support them either. If you came for a team scorecard, you are going to be disappointed by roughly the 20-minute mark. The second is more important, and I want it out in the open rather than lurking behind the argument. I have been one of Anthony Fauci's harshest critics for years, and I have not softened one single inch. I believe he lied to the American public repeatedly and knowingly. I believe the agents he led funded dangerous research abroad that should have been caught by the funding pause and the review framework in force at the time. That it was never submitted for the department-level review those rules contemplated, and that he gave misleading accounts afterward of what had been supported. I hold him responsible for a great deal of what was done to the country in the name of public health. None of that is in the past tense, and none of that is under revision today. The question today is whether a man I hold in contempt possesses a right that belongs to him because he is a person, and whether that right survives contact with a proceeding run by people who want him prosecuted. Because if the answer depends on how I feel about him, then there was never a right. It was a favor, and favors are withdrawn. Saturday, we spent an hour with the Levelers, with John Lilburne and Richard Overton and William Walwyn, and the agreement of the people, and the idea that a constitution should be a document of limitation rather than a grant of authority. Of everything that came out of that movement, one thread runs into American law by direct descent rather than by family resemblance, and tonight we follow it. As always, this episode expands upon the themes of the article, brings in additional sources, and takes up complexities the written format could not fully explore. So let us begin.
Welcome to the Consequential Actions podcast. Here we ask a simple question of the history and the actions that have shaped our lives.
Did this leave us more free or more governed? Because what we do not know can be used to govern us.
And what we choose to ignore always will.
In 1637, John Lilburne stood before the court of Star Chamber and was told to swear an oath. We need to be precise about what that oath was because the whole of this hour hangs on that mechanism. It was called the ex officio oath, and it did not work the way a modern courtroom oath works. A witness today swears to tell the truth, the whole truth, and nothing but the truth about a matter already specified. There is a charge, there is an accuser, there is an allegation on the table, and the witness answers to that. The ex officio oath came first and came empty. The accused swore before hearing any charge to answer truthfully whatever questions the court chose to put to him. He did not know what he was accused of. He did not know who had accused him. He did not know what the court already had. He swore blind, and then the questions began. Consider what that leaves a man. He may swear and answer truthfully and furnish the evidence that convicts him. He may swear and lie and commit perjury, which is a crime and, for a serious man of that century, a sin against God. Or he may refuse the oath and be punished for the refusal itself, with no trial on the underlying matter at all. 3 doors, all lead to the same room. Lilburne took the third. He would not swear. He told the court that he was not bound to accuse himself, and he stood on it. He was never tried for the thing they suspected him of. There was no verdict on the smuggling of unlicensed books, no finding of fact, no evidence weighed. His offense, the thing they actually punished, was the refusal. On the 18th of April, 1638, he was stripped to the waist, tied to the back of a cart, and whipped through the streets of London from Fleet Prison to Westminster, something on the order of 2 miles, with a whip of 3 knotted cords striking him the entire time. Then he was locked into the pillory in Palace Yard. While he stood there bleeding, he preached to the crowd and threw pamphlets into it. The court ordered him gagged, and he kept stamping his feet. Now, the path from that morning to the Bill of Rights is real, and it is documented. Parliament abolished Star Chamber in 1641 and dismantled the machinery of compulsory ex officio examination along with it. The principle then developed unevenly and over the following century into a settled rule of the common law, carried in a Latin maxim older than Lilburne himself. Nemo tentor septium accusiere. No man is bound to accuse himself. English lawyers carried it. English legal writers wrote it down. The colonists read those writers, and several colonies wrote the protection into their own charters and declarations of rights before there was a United States. And in 1791, it entered the Constitution in the form of the Fifth Amendment. In 11 words, no person shall be compelled in any criminal case to be a witness against himself. In 1966, the Supreme Court decided Miranda versus Arizona and required that a person held in custody be told what he has before he is questioned. Miranda did not create the privilege. The privilege was already 175 years old in the Constitution and centuries older than that in the law. What Miranda added was the warning, which is why every American who ever watched an hour of television can recite the sentence, "You have the right to remain silent." So when we say the Fifth Amendment stands in the same line as the leveler struggler, we are not gesturing at a mood. We are tracing one major channel of a much older tradition, one that runs through colonial charters, state declarations of rights, and the drafting of 1789 as well. And Saturday's episode drew that distinction, and it holds here. Notice what the line actually carries. The protection was not built to shelter the guilty. It was built to destroy a structure. The structure that offers a man 3 doors and puts punishment behind each one. That is the thing the Fifth Amendment exists to break. Here's the most common thing said about the Fifth Amendment in American life, and it is said by decent people who mean well. If you have not done anything wrong, why would you refuse to answer? I want to spend some real time here because that sentence is the single most dangerous misunderstanding an ordinary law-abiding person can carry around. And because almost everything that follows in this episode depends on taking that apart. Start with the Supreme Court of the United States, which has answered the question directly, unanimously, and recently. The case is Ohio versus Reiner, decided in 2001. The facts are terrible and they are worth hearing because it is not a case about a politician or a financier. A 2-month-old baby named Alex died of what the coroner called shaken baby syndrome. His father was charged with involuntary manslaughter. The father's defense was that he had not done it, that the injuries had been inflicted by the family's babysitter, a woman named Susan Batt, who had spent long stretches alone with Alex and his older brother in the weeks before the injuries were discovered. Susan Batt maintained that she had done nothing wrong. She also, on the advice of counsel, told the court that she would not testify without grant of immunity. And the Supreme Court of Ohio held that she had no Fifth Amendment privilege at all because she claimed to be innocent. Her innocence on that reasoning forfeited the protection. The Supreme Court of the United States reversed, per curiam, and it did not equivocate. The court had never held the privilege unavailable to those who claim innocent. To the contrary, one of the amendment's basic functions is to protect innocent people who might otherwise be ensnared by ambiguous circumstances. That phrase comes from an older case, Grunwald from 1957, and Grunwald explains the mechanism in a single line that I would put on the wall of every high school civics classroom in this country. Truthful answers from an innocent witness, no less than from a wrongdoer, can hand the government incriminating evidence out of the speaker's own mouth. Truthful answers from an innocent witness. Susan Batt was a babysitter. She had been alone with a child who died. A grieving father's entire defense was that she was the killer. Every honest answer she could give, where she was, how long, what she remembered, what she did not remember, was raw material for a prosecution of her. The court did not rule on whether she had done anything. It ruled that claiming she had not done anything did not strip her of the protection, because the circumstances were ambiguous and she was standing inside of them. That is the person the Fifth Amendment was written for, not the mob boss, the babysitter. Now I want to give you 3 cases. The first is a woman who was never charged with the crime everyone thinks she went to prison for. Martha Stewart sold about 4,000 shares of IM clone stock in December of 2001, one day ahead of bad news from the Food and Drug Administration, avoiding a loss of roughly $46,000. Federal prosecutors did not charge her with insider trading. They looked at it and concluded the evidence of an illegal tip was not strong enough to bring. That charge was never filed. Not dropped. Never filed. What they charged her with was conspiracy, obstruction of an agency proceeding, and 2 counts of making false statements. All of it arising from what she said to investigators about a stock sale they had decided they could not prosecute. And then there was a 5th count. They also charged her with securities fraud, and the basis for it was that she had publicly declared her innocence. The theory was that by saying she had done nothing wrong, she was propping up the share price of her own company, and that this made the denial itself a fraud on investors. Judge Miriam Cedarbaum threw that count out before it reached the jury. She wrote that no reasonable juror could find beyond a reasonable doubt that Stewart had lied for the purpose of influencing the market in her own company's stock. But understand what almost happened there. The government took a woman's public statement that she was innocent and tried to make the statement a felony. On the 4th of March 2004, the jury convicted her on the 4 remaining counts. She served 5 months at Alderson and then 5 months of home confinement. She went to prison for what she said about a sale that was never charged as a crime. The second story is about a retired 3-star general. On the 24th of January 2017, 2 FBI agents came to Michael Flynn's office in the White House and asked him about conversations he had held with a Russian ambassador the previous December. The conversations themselves were not charged as a crime then or ever. What Flynn said in the interview became the entire case, one count of making a false statement to a federal officer to which he pleaded guilty in December of 2017. He was not under oath. He was not read any warning. Section 1001 of Title 18 applies anyway. A person can commit a federal felony sitting in his own office in an unrecorded conversation without ever raising his right hand. Handwritten notes by the FBI's then counterintelligence chief, Bill Priestap, written on the day of the interview, contained this line: "What is our goal? Truth and admission, or to get him to lie so we can prosecute or get him fired." That line has been quoted 1,000 times. The same page also contains this line: "If we are seen as playing games, the White House will be furious. Protect our institution by not playing games." You do not get to quote the first without the second. I've watched people I generally agree with do exactly that, and it is dishonest, and it damages an argument that does not need the help. Both lines are on the page. Read together, they show an agency arguing with itself about what it was doing, which is more complicated and more human than a conspiracy. The Justice Department later moved to dismiss the case. A federal judge resisted. Flynn was pardoned in November of 2020, and the case was dismissed as moot. Whether he lied, whether he misremembered, whether the interview was fairly conducted, reasonable people land in different places. So we're not going to settle that one tonight. The only thing I need from the case is the structural fact, and it is not in dispute. The conduct they were investigating was never charged. The interview produced the felony. The third case has not yet happened, and it is the reason we are here tonight. Anthony Fauci has not been charged with anything. He holds a pardon covering conduct from 2014 through January of 2025, and on the 29th of July, before a Senate committee, he refused to answer questions more than 100 times. His stated reason was not that the answers would reveal a pandemic-era crime. His stated reason, in substance, was that he believed the hearing had been convened to get him to say something that could be measured against his prior statements and charged. Reporting since indicates his lawyers had been watching the House handle another witness closed-doors testimony and the referral that came out of it for allegedly false statements. Now, you may think that is a self-serving excuse from a man who deserves worse, and I've already told you what I think of him. But set aside that entirely and look only at the mechanism, because the mechanism does not know who you voted for. It caught a lifestyle executive who was never charged with the trade. It caught a decorated general over a conversation that was never a crime. It is the reason your lawyer, if you ever need one, will tell you to say nothing to a federal agent, no matter how innocent you are, and no matter how much of the silence makes you feel like a criminal. And there's one more thing about honest people, which is why the movie clip we are about to hear is doing real work and not just getting a laugh. There is a scene in the classic movie My Cousin Vinny, in which a young man is questioned by a sheriff after being arrested for a killing he had nothing to do with. Spoiler alert, if you haven't seen the movie from 1992, pause now, go watch the movie, and then come back.
You paid for the groceries. And then what?
We went out to the car, and that's it.
When'd you shoot him?
What?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
Hey, Dean, we need you out here. I'm in the middle of a damn confession here. I asked him if he did it, and he said, I shot the clerk. I asked him again, and again he said, I shot the clerk.
Your Honor, no further questions.
In the movie, he was told what he was accused of, and in complete disbelief, he repeats the accusation back as a question. I shot the clerk? The sheriff writes it down. In the courtroom, it is read back flat as a declaration. Same 4 words, no question mark, no raising of the voice. It is played for laughs, and it is entirely accurate about how this works. Speech is not a transcript. Tone does not survive a notebook. Disbelief looks identical to admission once the punctuation is gone, and the person who decides what the punctuation was is the person building the case. That is the whole problem in 4 words. An innocent man opened his mouth and handed the government its best evidence. And he did it while saying he had not done it. So the honest answer to why you would refuse if you have nothing to hide is this. You're not refusing because you have something to hide. You're refusing because your memory is imperfect, because your words will be written down by someone else, and because the person recording them has already formed a theory of what happened. A gap between your recollection and the government's evidence is not automatically a crime. A false statements charge requires proof that you knew the statement was false and that it mattered. But the government gets to decide whether to treat that gap as proof of a knowing lie, and defending that accusation can become the entire case, long after the investigation that started it has produced nothing. The right is not a hiding place for the guilty. It is a wall between an honest person and a machine that was not built with him in mind. The privilege is not unlosable. A person can give it away, and the law about how is the reason a committee voted the way it did 5 days ago. The doctrine is called Waiver, and the principle behind it is fairness rather than punishment. A witness may not testify to the parts that help him and then refuse the parts that do not. He cannot tell his own story and then decline to be tested on it. If he opens the subject, he has to stay for the questions. That is sound. Nobody serious disputes it. The fight is always over what counts as opening the subject. Which brings us to Lois Lerner, and to a precedent that almost nobody discussing this month's hearing has bothered to look up. In May of 2013, Lerner was a division director at the Internal Revenue Service, at the center of what became known as the targeting of conservative groups applying for tax-exempt status. She was called before the House Oversight and Government Reform Committee. She delivered a short opening statement in which she said that she had not done anything wrong, had not broken any laws, had not violated any regulations, and had not provided false information to Congress. Then she invoked the Fifth Amendment and declined to answer questions. Committee Republicans said that was a waiver. You do not get to proclaim your innocence to the cameras and then refuse cross-examination. Trey Gowdy, a former prosecutor, laid out the specific statements. On the 28th of June 2013, the committee voted 22-17 that she had waived the privilege. In May of 2014, the full House voted to hold her in contempt. Every Republican and 6 Democrats. The referral went to the United States Attorney for the District of Columbia, a man named Ronald Machen, appointed by President Obama. And on the 31st of March 2015, Machen wrote to Speaker Boehner and declined to bring the case. His reasoning is the part that matters. Machen agreed with the committee on procedure. He rejected the argument that oversight had failed to properly notify Lerner that her privilege claim was overruled. He did not decline on technicality, and he did not decline because he liked her. He declined because he concluded that the waiver theory was wrong as a matter of law. Lerner had made only general claims of innocence, and a general assertion of innocence is not a testimony about the facts. It opens no subject, it tests nothing. And therefore, Machen wrote, the Fifth Amendment would give her an absolute defense if she were prosecuted for refusing to testify. He would not take it to a grand jury. Republicans were furious. and said so at volume. Jim Jordan said Machen had used his office as a political weapon and ignored an obligation to convene a grand jury. Now, keep that entire episode in your head, because here's what happened 5 days ago. Senator Rand Paul's contempt resolution alleges Anthony Fauci waived his right to claim the privilege because he had opened his testimony with remarks. That is the Lerner theory. Not a relative of it, the same theory, on the same statute, over the same kind of statement, argued by the same party and rejected by the Justice Department 11 years ago on the ground that it is not good law. Now, in fairness, and this is a real distinction, not a courtesy, Fauci's opening statement was not a bare recital of innocence. He accused the chairman of unhinged obsession with him, and he characterized the hearing itself as an attempt to get him to say something that could be used to prosecute him. That is closer to argument about the proceeding than Lerner's flat denial was. Now, whether it constitutes testimony about the underlying facts is exactly the question. But the shape of the thing should stop us and cause us to pause. In 2013, a committee decided that an official's opening statement forfeited her constitutional protection. A prosecutor from the other party said no. In 2026, a committee has decided that an official's opening statement forfeited his constitutional protection, and that also will go now to a prosecutor. Which is where Saturday's document has something to say. The agreement of the people, reserved among the things that no government could touch, that in all laws made or to be made, every person may be bound alike, that no tenure, estate, charter, degree, birth, or place should confer any exemption from the ordinary course of legal proceedings whereunto others are subjected. Bound alike. This is one of the shortest clauses in the document and one of the most demanding, because it does not ask whether a rule is good. It asks whether the rule you apply to him is the rule you will accept applied to you. A waiver doctrine that reaches a Democratic official in 2013 has to reach a Republican one in 2029. A committee that can overrule a privilege claim by majority vote is a committee that can do it when the majority changes. There is no version of this where this tool stays in one party's hand. And now the pardon, because none of this argument exists without it. Senator Paul's case was not primarily about waiver. It rests on something simpler and on its face, stronger. His words at the markup: the committee was voting on whether a witness who has received the benefit of a sweeping federal pardon can be ordered to answer questions and then defy that order without consequence. The law behind it is real, though the leading case is not quite the one people reach for. In Brown v. Walker, decided in 1896, the Supreme Court upheld a federal statute that compelled testimony before the Interstate Commerce Commission by granting the witness immunity from prosecution. Brown was a railway auditor. He had no pardon. What the court held was that when the law has genuinely removed every realistic danger of prosecution, the privilege has no remaining work to do. And in the course of saying so, it observed that a man who has already received a pardon stands, as to that offense, as if it had never been committed. So the sentence Paul's argument rests on is in the opinion. It is not in the holding. Take the argument at full strength anyway, because it is strong. Fauci holds a pardon covering conduct from 2014 through the 19th of January 2025. The principal historical period under investigation, including the pandemic-era conduct and its earlier congressional testimony. He cannot be federally prosecuted for any of it. The danger the Fifth Amendment guards against has been removed by the only person with the power to remove it. And a man with no jeopardy who refuses to answer anyway is not protecting himself from prosecution. He is declining to participate, and there is a statute for that. Now the answer. And let's be very careful, more careful than I would like to be, because the easy version of the answer is incorrect. The easy version is that he might be prosecuted for what he says at the table. That is true of every witness who ever lived and is not a Fifth Amendment claim. The privilege protects a man from being forced to give truthful answers that would incriminate him. It does not protect lying. The federal immunity statute makes that point in black letter. A witness compelled to testify under grant of immunity may still be prosecuted for perjury or false statement. So set that aside. The real question is narrower and more difficult. Could a truthful answer to a particular question still furnish evidence against him? There are three places it might. It might point to something he said or did after the 19th of January 2025, which the pardon does not reach. It might expose him under the law of some state, which a federal pardon cannot touch, though that requires an identifiable offense and a realistic possibility of prosecution, not the bare existence of 50 criminal codes. Or, and this is the one nobody on either side wants to say out loud, it might incriminate him for exactly the pardon conduct if the pardon is not worth what it claims to be worth. And here I have to be honest about where my own argument sits in the case law, because it does not sit in the majority. The two answers I just gave, that compelling a man to speak manufactures a perjury exposure he would never have faced in silence, and that a federal shield does nothing about a state prosecutor, were both made in Brown versus Walker. They were made by Justices Gray and White in dissent. They lost 7-2. So I'm not going to hide behind that rhetoric. Half of what I just told you was rejected by the Supreme Court 130 years ago. But only half. And this is worth the 60 seconds it takes. The perjury argument stayed lost, and it should have. A man compelled to testify may still be prosecuted for lying, and that is the law today. The state argument did not stay lost. In 1964, in Murphy versus Waterfront Commission, the Supreme Court held unanimously that the privilege protects a state witness against incrimination under federal law, and a federal witness against incrimination under state law. It overruled the older rule that one government in our federal system could compel testimony and leave another free to use it. On the cross-sovereign point, Gray and White lost in 1896, and on their central claim, they prevailed unanimously 68 years later. Not the whole of the dissent. The perjury half stayed buried, but the half that matters here. So a federal pardon cannot end the inquiry merely because federal persecution has become impossible. The danger from another sovereign still counts, though it has to be real and appreciable danger, arising from an identifiable offense and a realistic possibility of prosecution, and not the bare fact that 50 state criminal codes exist. I've not seen anyone name that offense in the Fauci case. Which brings the whole thing back to the only question that actually matters here. Who decides whether the danger is gone? A committee may reject a privilege claim in the first instance and direct a witness to answer. That much is ordinary. What a committee cannot do is make its own constitutional conclusion final by voting for it. Before criminal punishment can lawfully follow, a court has to be able to look at the questions actually asked, and whether a truthful answer to each could reasonably have furnished a link in a chain of evidence leading to prosecution, and at whether the refusal was protected. That review would likely go badly for Fauci on a good many of those 100-odd questions, because some of them, on their face, are hard to connect any realistic criminal exposure. The point is not that he wins. The point is that the committee's vote cannot make him lose conclusively. And that is where Burdick comes back, though it does less work than I would like. The court did hold that an unsolicited pardon must be accepted, that a man may refuse one, and that acceptance carries an imputation of guilt, which is why Wilson's people could not simply hand George Burdick a piece of paper and unlock his testimony with it. Whether Fauci has legally rejected his pardon is a different matter, and nothing in the record says that he has. Later cases have also warned against stretching Burdick's consent reasoning to every pardon and commutation. So Burdick does not settle this. What it establishes is narrower. In the situation it presented, the executive could not force an unsolicited pardon on a witness for the sole purpose of destroying his privilege. Whether that rule reaches a pardon like Fauci's, never explicitly rejected, is unresolved. Now let me turn to the pardon itself, because I do not think it should have been issued, and I want to say why carefully rather than loudly. I've heard it said that preemptive pardons are new innovation. They are not. and anyone who says so on a podcast is going to be corrected by lunchtime. Gerald Ford pardoned Richard Nixon in 1974 for offenses he had committed or may have committed across a 5.5-year window, with no indictment ever returned and no offense named. Jimmy Carter pardoned an entire class of Vietnam-era draft offenders by proclamation in 1977, most of whom had never been charged. The Supreme Court said in Ex parte Garland back in 1866 that the pardon power may be exercised at any time after the commission of an offense, before proceedings are taken, during their pendency, or after conviction. So the category is old. But what happened in January of 2025 was something else. On the 20th of January 2025, President Biden issued preemptive pardons to Anthony Fauci, to General Mark Milley, and to every member and staff of the House January 6th committee, along with the police officers who testified before it. And then in the last 20 minutes of his presidency, to his brothers James and Francis, his sister Valerie, and their spouses. His son had been pardoned the previous December, after the president had said publicly he would not. Ford pardoned his adversary he had displaced. Carter pardoned a class defined by an act. This was two groups. They are not the same and should not be defended or attacked as though they were. The first, Fauci, Milley, the committee members and staff, and the officers who testified, was defined by exposure to anticipated retaliation, which is at least a recognizable reason. The second, issued 20 minutes before the end, was defined by being the president's brother, the president's sister, and the people they married. And that one is harder to defend, and nobody has really even tried. And listen to the words that came with it. Biden said the pardons should not be mistaken for any acknowledgement that anyone is engaged in wrongdoing. Benny Thompson and Liz Cheney said in a joint statement that they had been pardoned not for breaking the law, but for upholding it. Mark Milley said he did not wish to spend his remaining years fighting people seeking retribution for perceived slights. Every one of them insists there was nothing to forgive. In my judgment, the instrument has come loose from its core. The traditional heart of a pardon is forgiveness for an offense, though presidents have long used it for amnesty or political settlement too, as Ford and Carter show. What was issued that morning was something further out than either. A document declaring that a named set of people, all of whom maintained there was nothing to forgive, could not be federally prosecuted for anything they did across a span of 11 years. It does not stop an investigation, a subpoena, a state prosecutor, or a newspaper. What it stops is the ordinary federal criminal process for a list of people chosen in advance. And the levelers had a name for that kind of paper. Not a pardon, a charter, a grant of exemption to men in favor, exactly the sort of clause in the agreement was written to abolish. No tenure, estate, charter, degree, birth, or place conferring exemption from the ordinary course of legal proceedings whereunto others are subjected. Birth or place. Birth is where you were born. Place is the office you hold. The clause refuses exemption on either ground. Neither your family nor your position gets you out of the process everyone else is in. Senator Mark Wayne Mullen asked the obvious question at the time and has never been answered. If they did nothing wrong, why the pardon? Whether the courts would strike such a thing down is a separate matter. And let's be honest that my position is the minority one. The text gives the president power to pardon offenses against the United States. My reading is that at some point a document covering an 11-year window and naming no offense stops pardoning offenses and starts conferring a status. And I do not think the text authorizes conferring a status. That argument has not won anywhere. It may never be tested because no one has standing to challenge a pardon until a prosecutor tries to charge past it. But the prudential argument does not depend on winning that fight. A president who blankets his own people in immunity on the way out the door has handed the next president a tool. And tools like that do not go unused. This is not a prediction about anyone's character. It is a statement about what happens to instruments once they exist. And now the part that makes this an actual conundrum instead of a complaint. The pardon issued to protect Anthony Fauci supplied the committee's strongest argument for putting him in jeopardy today. Follow it. The pardon closed the door on the old conduct federally. That closure is the strongest argument that the privilege has lapsed. That argument is what justified ordering him to answer. And the order is what produced the contempt referral when he would not. Without the pardon, Senator Paul loses his broadest claim, that Fauci's exposure had been categorically erased. He could still argue waiver and could still argue that particular invocations were unjustified, but he could no longer say the whole historical subject had been placed beyond federal reach. A shield that supplied the committee's best argument for putting the man it protected in jeopardy over his silence. That is not irony. That is what happens when you take an instrument designed for one purpose and use it to confer a status it was never meant to confer. And it's worth noting where my own argument lands, because it lands somewhere uncomfortable. If I am right that the pardon exceeded the president's power, then the premise of the senator's categorical argument disappears. Fauci would carry substantial federal exposure for the whole period, and a great many of his refusals would become far stronger. Not all of them, because a blanket claim across 100 questions would still have to be justified question by question. But the strongest thing anyone has said against his privilege would be gone. I do not get to hold both halves of that, and neither does anyone else. So the 29th of July, 2026, Anthony Fauci appeared under subpoena before the Senate Homeland Security and Governmental Affairs Committee, chaired by Senator Rand Paul of Kentucky. He delivered an opening statement. He said the chairman had an unhinged obsession with him and suggested the hearing had been convened to trick him into lying under oath. And then he said this, or something very near it, more than 100 times across 2 to 3 hours. Under the advice of my attorneys, I will invoke my right under the Fifth Amendment of the Constitution to refrain from answering your questions. He prefaced it the first time by saying it pained him to do so out of respect for the legislative branch and a decades-long record of cooperating with Congress. The chairman denied the assertion of privilege and directed him to answer. He refused. At one point, Capitol Police removed his attorney from the room after the lawyer spoke without being recognized. On Thursday, the 6th of August, 5 days ago, the committee voted along party lines to hold him in contempt of Congress. The count was 8-5, with 2 votes by proxy, along party lines. Senator Paul said the first thing he would do was refer the matter to the Department of Justice. Conviction under the contempt statute carries a fine of up to $100,000 and a term of imprisonment up to 12 months. Now, before I say what I think, 3 things cut against a simple story. The referral is not a verdict. The committee approved a contempt resolution and set the referral process in motion. It did not convict anyone, and it did not conclusively settle the privilege question. The Justice Department decides whether to charge. A court would ultimately decide whether particular questions were protected. If it charges, Fauci gets an indictment, a lawyer, discovery, a jury, and every protection this hour has spent 40 minutes defending. Some have objected that this matter is going toward the department without a vote of the full Senate. That objection is not frivolous. The statute does not expressly demand a full chamber vote in every case, and committees have sometimes directed referrals, and yet the full chamber approval is the traditional course. And at least one court suggested that it may be required. It's an unsettled question. What I will say is that the complaint is not the constitutional problem here, because a different branch reviewing a congressional referral is the separation of powers working. It's not being evaded. And the records show that the review is real. Bannon and Navarro were referred and prosecuted and served time. Lerner was referred and the prosecutor said no. By the Justice Department's own account in the Lerner matter, no United States attorney had pursued a congressional criminal contempt referral of this kind since 1983 against the head of the EPA. Second, this mechanism has run in the other direction recently. Steve Bannon and Peter Navarro went to federal prison on contempt of Congress during the previous administration on referrals from a Democratic House. Many of the people applauding this week's vote condemned those prosecutions, and many of the people condemning this week's vote applauded them. That's worth saying out loud. Do you really get to have it both ways? Third, the Democratic objections are not clean either. Senator Peters called it a one-sided investigation and a rushed process. He may be right about both. He was not, so far as I can find, similarly troubled when the machinery pointed the other way. The strongest thing said in Fauci's defense came from his own lawyer, and it is an argument about motive rather than principle, that Paul has proclaimed for years that Fauci should be prosecuted and imprisoned. So set the motives aside. Everyone in that room has them. Look only at the structure of the choice the committee has presented, because the structure is the thing this episode is about. Anthony Fauci said, in effect, I will not answer because answering will be used to build a case against me. The committee's response was to reject that claim, direct him to answer, and then vote to seek criminal punishment when he would not. Notice the sequence, because everything turns on the same body taking every step. The committee asked the question. The committee ruled on the objection to its own questions. And then when the witness disagrees with that ruling, the committee voted to set the criminal machinery in motion against him for disagreeing. It is not the prosecutor and it is not the final judge. I said so a moment ago, and I will say it again. The Justice Department decides whether to proceed, and a court would decide whether the questions were pertinent, whether he had a reasonable cause to fear that a truthful answer could furnish a link in a prosecution, whether he waived, and whether the refusal was willful. But it asks the questions. It rules in the first instance on the objection to its own question, and it decides whether to set the criminal process in motion when the witness will not accept that ruling. 3 things in one room on one afternoon. Now the comparison to Lilburne. Lilburne was made to swear before he knew the charge, to answer whatever they chose to ask, and the whip attached directly to the refusal, and no court anywhere to appeal to. Fauci walked in with counsel, knowing the subject, holding a pardon that covers most of the underlying conduct, and refused more than 100 separate questions, including some where the truthful answer is hard to connect to any realistic criminal exposure. He faces a referral to a prosecutor who may decline, and if the prosecutor does not decline, then a judge and a jury. 380 years of constitutional development sit between the whipping and this, and every year of it was worth having. So this is not Star Chamber. What it is a recognizable descendant of a particular thing Star Chamber did. Not the cruelty, the arrangement. The body conducting the inquiry decided for itself that the witness had nothing to fear, and then treated his disagreement as an offense. That is the piece the Fifth Amendment was built to break, and it survives the difference in severity entirely. If the danger is really gone, then Fauci's blanket refusal was tactics. He should answer, and the validity of each refusal should be tested against the actual questions asked. If the danger is not gone, then he is facing prosecution for exercising a right. Either way, the institution whose conclusion should not be the last word is the one that issued the subpoena and wants him prosecuted. The safeguard was never that the witness always wins. It is that the investigating majority does not have the final say. And that is the whole of my objection. It does not require believing Senator Paul acted in bad faith. It does not even require believing Senator Fauci was right. It requires only an asking who gets to decide, which is the same question the series asked 2 weeks ago about a measuring rod and got the same answer. Senator Paul said on the record that there would be repercussions for the refusal to testify. A man was whipped 2 miles through London for exactly that, and his punishment became one of the defining episodes of the Anglo-American rejection of compelled self-accusation. This is the part of the episode, and regular listeners will be familiar with it. It's termed in my notes, The Reckoning. And this one is particularly glaring. The first reckoning has to start with me. I told you at the top that I believe Anthony Fauci lied to this country and helped fund work that should never have gotten past the rules in force at the time. I meant it, I mean it, I will continue to stand by that. But I have to tell you, when I first saw the clip of him invoking the fifth for the 100th time, my first reaction was not constitutional. It was satisfaction. There he is, I thought, finally, being shown for what he is. And that reaction is the thing this episode exists to argue against. And I had it before I had a single thought about Lilburne. And if I am honest, the hour you are listening to is partly an argument I have had to have with myself first. And I do not think I would have written it as carefully if the man in the chair had been someone that I liked. Second, the movement. We have been inconsistent about this, and we should stop pretending otherwise. When witnesses invoked the Fifth before the January 6th committee, a great many people on my side of the ideology explained correctly that invoking the privilege is not evidence of guilt, that the committee was a political proceeding. Some of us even called it a banana republic or a kabuki theater, and that a man is entitled to counsel's advice. When Anthony Fauci did the identical thing before a committee chaired by a libertarian Republican, a great many of the same people called it a confession. Each side did the mirror image on the same two events in the same 4 years. Nobody comes out of this clean. But I'm not responsible for their consistency. I'm responsible for ours. And third, and this is the hard one, Senator Paul. Rand Paul is, on most days, the best friend of the Bill of Rights has in the United States Senate. He has taken lonely votes on surveillance, on war powers, on civil asset forfeiture, on no-knock raids. When this program has needed an example of a legislator who actually reads the Constitution, his name has come up more than once and will again. He has been right on Anthony Fauci, on the substance for years, and mostly alone in it. And history is going to treat that better than his colleagues did. And he is wrong here. Not wrong about Fauci, wrong about the door. There was another route available. Congress can compel testimony by granting use immunity. A 2/3 committee vote and an order from a federal judge, and the witness must then answer because the answers cannot be used against him. It is a real tool. It exists precisely for this situation, and it was not used. I will give that the honest complication. Immunity would not have solved this problem either, because the immunity statute expressly permits prosecution for perjury. A witness who lies under a grant of immunity can still be charged for the lie, so the tool would not have removed the exposure Fauci actually named. But it would have been an attempt to get answers. Criminal contempt at this stage is principally punitive. It may pressure a witness toward cooperation later, and I will not pretend that it never does. What it does not do is produce a single answer to a single question the committee says it wants answered. Fourth, the document we admired on Saturday. The agreement of the people reserved that no man should be questioned for anything done in the late Republic differences, other than an execution of judgments of the present representative. An indemnity written into a constitution for a whole class of conduct in advance. I've said tonight that Biden's pardons were a charter of exemption. The levelers wrote an exemption into their own founding document. I do not think the two are equivalent, and I have said so when I first considered it. Indemnity at the close of a civil war for men who fought in conditions they did not choose and had to be able to lay down their arms without fearing the rope is not the same as an act of immunizing officials for peacetime administrative conduct. I'm not going to pretend that it is. But there's one thing to carry across, and it is uncomfortable. Indemnity is always written by whoever is holding the pen when the fighting stops. A settlement that covers everyone is a peace term. A settlement that covers your own people is a spoil of victory. Ford said the country could not heal. Biden said that his people faced politically motivated prosecution. The agreement said the late public differences. The reasons sound familiar, even when the circumstances do not, and the familiarity is the warning. Fifth, and last, and this cuts against my own conclusions. If the Fifth Amendment means what I have said it means for 235 years, and for Susan Batt and John Lilburne, then it means it for a man who did real harm to this country. And it means the questions I want most answered may never be answered. There are things I want to know about the origins of a pandemic in which more than 1 million deaths were recorded. We may not get them. Not because the truth does not matter, but because the method for extracting it costs more than the truth is worth. That is a real loss, and I'm not going to dress it up as a victory. Some things that a free people would very much like to know, a free people does not get to have. So that was the reckoning, but now the skeptic's case, and there are 3 objections to everything that I've said. And so let's discuss them. The first objection is that you have spent an hour building a principle whose sole practical effect today is to shield a man you have accused, in your own words, at the top of this episode, of lying to the country and funding research that should have been stopped by the rules in force in a chain you believe ends in 1 million graves. Every link in that chain is contested, and you know it, and you asserted it anyway. And now you are protecting the man from having to answer for any of it. You said your position out loud in the introduction, which is a clever way of getting credit for the honesty without paying for the consequence. The principle is not free. It has a price, and that price is that he walks, and you have chosen, in the concrete case in front of you, the abstraction over the million. A serious person weighs consequences. You have weighed a maxim. The second objection is legal, and it does not need any of that. Your Lerner parallel is weaker than you made it sound. Lerner offered a general denial. Fauci offered an agreement about proceeding, accused the chairman of an obsession, and characterized the committee's motive. That is closer to substantive testimony than you conceded as much, then moved on quickly. Machen's letter binds nobody. It was one prosecutor's declination, not a holding of any court, and it was written by a political appointee about an official of his own administration. Meanwhile, Brown versus Walker is an actual Supreme Court decision saying a pardoned witness has no privilege, and your answer is a set of hypotheticals. He might face state charges. He might be charged with something he says at the table. Might. A blanket invocation to more than 100 questions, including questions where no conceivable answer creates exposure, is not a good faith assertion of privilege. It is a strategy, and the law does not protect strategies. The third objection is about the whole enterprise. The levelers lost. Their constitution was never adopted. The men at Burford were shot against the church wall, and the reason is that their document was a list of things government could not do, unbacked by any machinery to stop it from doing them. You are doing the same thing tonight, reading a clause aloud and expecting it to hold. It did not hold for Lilburne, who was tried again and jailed again after Star Chamber was abolished, by Parliament, by his own former allies. It is not holding now. Words on parchment do not restrain power. Only power restrains power, and the Fifth Amendment is a sentence in a document that a committee just voted to override. Those are the three toughest objections I've seen to this. So let me take them in order, and let me concede first because all three do deserve it. To the first, I concede the price entirely. The skeptic is right that the principle has a cost, and right to say that I have to pay for it in the concrete case rather than in the abstract. What I will not concede is the arithmetic because it does not work the way it looks. The choice on offer is not between the truth about the pandemic and one man's comfort. The Fifth Amendment does not stop a single investigation. It stops one method. The method of turning the suspect into the instrument. Documents, emails, subpoenas to other witnesses, testimony, the grand jury, journals, phone records. All of it remains. Senator Johnson's committee has Fauci's phone. Comer's committee has the journals. The record is being built, and it is being built the way records are supposed to be built, out of evidence, rather than out of the mouth of the accused. And the arithmetic runs the other way, too. A right that yields when the crime is serious enough is not a right, because every prosecutor in America believes the case in front of him is serious enough. That is not cynicism about prosecutors. It's their job to believe it. The protection is worth exactly as much as it is worth in the case where you least want to apply it, which is why the case you least want to apply it is the only real test of whether you have one. To the second, I concede more than the skeptic expects. The distinction between Lerner's general denial and Fauci's characterization of the proceeding is real, and I said so in the body rather than hiding it. Machen's letter is declination, not a precedent, and it binds nobody. Brown versus Walker is good law, and the blanket invocation across more than 100 questions is the strongest single point against Fauci, because some of those questions plainly carry no exposure at all, and refusing them looks like tactics rather than fear. One answer, and is the only one I need. The remedy for an overbroad claim of privilege is a question-specific legal review, an examination of the actual questions asked and whether the truthful answer to each could reasonably have furnished a link in a criminal case. In a congressional matter, that review may arrive late. Through a prosecution or an immunity proceeding rather than before the committee acts, and I concede that a witness is not owed a judge's ruling in advance. If the skeptic is right that Fauci's invocation was a strategy, and he well may be, that review is exactly what would expose it. So the objection is an argument for the review, not against it. What it cannot support is treating the committee's own conclusion as the end of the matter. And to the third, I concede almost the whole objection, and it is the best one. The skeptic is right that the levelers lost, right that the agreement was never adopted, right that Lilburne was jailed again by Parliament after Star Chamber fell, right that the words on parchment restrain nobody by themselves. Saturday episode said all of it. Here's what survives anyway. The clause did not stop the Star Chamber, but the Star Chamber is gone. And the ex officio oath is gone. And 11 words in the Fifth Amendment are the reason we are having this argument at all, instead of watching a man get whipped. Fauci is not being whipped. He's being referred to a prosecutor who may decline. And if he does not decline, there is a jury at the end of it. That is not the clause failing. That is the clause working slowly with enormous friction at a fraction of the strength its authors wanted. The levelers did not get their Constitution. They got a sentence into ours. On the evidence of the last 4 centuries, that is what winning looks like on a long enough timeline. And that is why the argument is still worth having on a Tuesday. So let us apply the test the series always comes back to. Did it leave Americans more free or more governed? Working through the delegation logic, a government is a group of people. Fancy hats and larger mobs confer no new moral powers. A body can only ever exercise authority its members actually possess to give. Richard Overton wrote the premise from a cell in Newgate in 1646 and is still the cleanest statement of it in the English language. No man has power over my rights and liberties, and I over no man's. First question, could you do this? Could you summon a neighbor to your house, require him to answer whatever questions you choose to put to him, and lock him in a cage for a year if he declined? You could not. Not if you believed him guilty of something terrible. Not if you were certain. Not if you were right. There is no version of your moral authority over another man that includes compelling his speech under threat of a cage. Second question. Can you hand over an authority that none of its members possessed walking in? It cannot. 15 senators in a hearing room are 15 people, none of whom individually held the power to compel a 16th person to speak. A gavel does not manufacture that power. A subpoena does not manufacture it. A recorded vote along party lines does not manufacture it. The vote only distributes the responsibility for the act thinly enough that no single person has to carry the weight. It's exactly what I said on Saturday. And it's the oldest trick in the history of collective action and the reason this test exists. Now the honest limit. Compulsory process is not nothing. A justice system that cannot compel any testimony at all cannot function. And the Constitution itself gives the defendant the right to compel witnesses in his favor. So there is a real power here that individuals do not hold, and delegation of logic alone does not resolve where that edge falls. The Fifth Amendment is where the founders drew that edge. You may be compelled to appear, compelled to be sworn, compelled to produce documents, and you may not be compelled to be the instrument of your own prosecution. That line was not drawn because it is convenient. It was drawn because a man was whipped 2 miles through London for standing on it, and his struggle entered the legal tradition the founding generation inherited. So more free or more governed? If a committee may decide for itself that a witness had nothing to fear and then set criminal machinery in motion against him for disagreeing, and if that determination is treated as settling the matter, then every American called before any committee has been told what his silence is worth and who sets the price. That is more governed. Not because Anthony Fauci is sympathetic. He is not, at least not to me, but because the rule announced in his case does not stay in his case. It never does. And the test cuts at the pardon, too, in the same direction. A document that lifts a class of people out of the ordinary course of law because of who they served and whose brother they are is a grant of privilege. And no majority and no president possesses a moral authority to confer one. More governed there as well, just governed differently from above by favor. Both halves of this story are the same failure. Someone deciding that the ordinary rules apply to other people. On Thursday, Brendan Kirby joins me. He has spent 30 years in the courtrooms and newsrooms in Mobile, Alabama, and he understands the machinery in this episode from the inside. Not as doctrine, but as a thing he watched happen to people. We talk about what the collapse of the newspaper business has done to the public's ability to find anything out. About a publisher and a reporter in a small Alabama town who were arrested and charged with felonies over a story. And about the distance between what a law says on paper and what a citizen actually gets when he asks for the record. If Saturday was about writing liberties down, Thursday is about what happens after the ink dries. Saturday, we watched the movement lose. The agreement of the people was never adopted. The men who wrote it were jailed, and 3 of their soldiers were shot against the church at a wall at Burford. And the Restoration buried the whole business so thoroughly that most Americans have never even heard the word leveler. And the principle Lilburne was whipped and jailed for is part of the inheritance that lets a man in a Senate hearing room decline to answer a question at all, and the reason that people asking the questions do not get the last word on whether he may. That is inheritance, not a guarantee, a sentence in a document that has to be argued for again in every generation by people who would frequently rather not. Tonight it has to be argued for on behalf of someone I cannot stand. That is not a flaw in the argument. That is the argument. A right that only protects the people you like is not a right at all. It is a courtesy. And courtesies are withdrawn by whoever is holding the gavel. John Lilburne understood that from inside the pillory, with his back open and his mouth gagged, still stamping his feet. I am Jeff Gellick, and this has been Episode 9, Part B of Self-Evident, The Road to 1776 on the Consequential Actions Podcast. If you have enjoyed this episode and want to follow the series, please subscribe to our Substack page at consequentialactions.com, where you will find all written articles, as well as our previous series on the General Welfare Clause, the New Leviathan, and the Empire of Liberty. Subscribe to our YouTube channel at Consequential Actions Podcast for video versions of all of our podcast episodes. And follow me on X at jkellick for updates, discussion, and announcements. We continue to post articles and welcome your participation. Until next time, have a great day.